My name is Franza. Welcome to Insight News. I will be covering a news reporter that just recently sent me breaking news that we are all shocked by. 2 tankers were on a highway that crashed and spilled crude oil into a water encampment. And this was around Sungai Gombak. We will go to my colleague, Miss Amira, who will be reporting on the scene right now.
Assalamualaikum and hi, thank you Miss Fanta. So as we can see, the situation here is a bit chaotic, and because it was just happened 45 minutes ago. It come to my knowledge that there was a collision between the 2 tankers and accidentally spilled the palm oil they carry in one of the tankers on the highway. Moreover, the collision happened because of the poor road due to the highway construction, where only one lane was open for them to drive. So I guess here that the crude palm oil also spilled into the drainage system and contaminated the Sungai Gombak, which now affecting the water supply which owned by the Puncak, Niaga and Shabas. And it looks like the Shabas and both of the parties need to shut down of the Gombak water treatment plant for a few days to recover back the contaminated water. I'm Umaira Shahira, and that's all from me. Thank you. Going back to the studio.
Thank you, Ms. Amira, for the reports. It seems like the people in that area need to prepare for some significant preparations, and that's all the news reporting from today. Thank you.
The first issue of the case is whether the defendants were liable for the contamination and the resulting damages. Second, whether it is reasonably foreseeable that the plaintiffs will suffer losses and damages due to the negligence of the first and or second defendants. Third, whether the plaintiff contributory negligence in not taking measures to prevent contamination.
Arguments from the plaintiffs. So the plaintiff filed an action in 2006 under the tort of negligence, alleging that as a result of the collision, most of the crude palm oil contained in both tankers spilled onto the road. So these suffering losses damaged include the necessary shutting down of Gombak WTP. Void when something is that lacking or absent. The statement of defense from the first defendant denies liability and pleaded that the alleged contamination and polluting of the river, which is not admitted, is too remote in law to sustain the plaintiff's claim, and that the alleged contamination and pollution was caused by the first plaintiff. The second indemnity insurance policy taken and/or subscribed by the first plaintiff to protect from any incidents of disruption to the supply of raw water supplied to the water treatment plant. And the insurance policy taken or subscribed by the second plaintiff is also to protect from any incidents by the second plaintiff, to protect from any disruption to supply of treated water supplied to the water treatment plant.
Now, let us look at the arguments from defendants. The first argument was the accident was not entirely caused by the defendants, but also by second defendants who suddenly stopped and the poor road conditions due to highway construction, where only one lane was open. Second, Puncak Niaga didn't put any signs to warn users of the existence of the water catchment area. Third, first defendant could not have foreseen that spilled oil from the accident would cause contamination to the water catchment area and make the plaintiffs suffer losses. Fourth, Puncak Niaga also failed to install safety measures to prevent contamination from such spills despite a similar incident happening before. And lastly, the first defendant's duty of care is only towards road users, not the plaintiffs.
Okay, the decisions that are based on the plaintiffs are based on the damage to the first defendant's tanker. The spillage of crude palm oil onto the highway resulted in Sungai Gombak and the Gombak intake to be contaminated or polluted. Was caused by the first defendant who had negligently rammed into the rear of the second defendant's tank. The second part is the defendant whom at the time of the accident were carrying crude palm oil owed duty of care, has road users were aware that it would be dangerous if the crude palm oil escapes from the tankers onto the highway. The location where the collision occurred at KM 229.2 had been gazetted as a water catchment area, which a statutory duty is imposed upon the defendants, a duty of care to the plaintiffs who are relying on the water catchment as a mean of business, And the fourth is the imposition of the statutory duty is imposed a duty of care upon the defendants in that they could have foreseen the plaintiffs would be to put expense and suffer losses if the water catchment area was contaminated due to their negligence. Now, for the defendants, is the first part. The collision was not solely caused by the first defendant, but the sudden stop of the second defendant's driver and the limited traffic due to highway construction. The third and second is that they failed to inform road users about water catchment area along the highway, and the first defendant was unaware of it, resulting into no duty of care towards the plaintiffs. Due to the potential contamination and loss, they also failed to prevent the pollution from oil spillage to Sungai Gombak, as well as not installing any safety mechanism. This incident also occurred in 2002 due to a road accident and should have taken precautionary measures. In general, the first defendant only owes a duty of care towards the road users on the highway, but not the plaintiffs.
Now, moving on to the ratio decidendi of the case. The first ratio decidendi that we identify is negligence and duty of care. Defendants owed the duty of care in a way they were aware that it would be dangerous if crude palm oil spilled onto the highway. Defendants also owed duty to the plaintiffs due to the potential for environmental contamination. The duty arose from the statutory prohibition against polluting gazetted water catchment area under Section 25 of the Environmental Quality Act 1974. Second ratio decidendi is causation and foreseeability. The defendants could have reasonably foreseen the spillage resulting from negligent driving near a water catchment area would lead to contamination and consequential damages to the plaintiffs who are relying on the water source as their means of business. For the last ratio decidendi is damages and contributory negligence. The plaintiffs awarded with nominal damages despite their failure to strictly prove specific losses. Next, the court rejected arguments of contributory negligence on the part of Puncak Niaga, which failing to install protective measures or signage, concluding that the primary cause of harm was the first defendant's negligence.
Cases related to the relevant case, which are two cases, one case from the UK and one local case. The first case is East Suffolk Rivers Catchment Board and Kent and another, 1947. The facts of the case state that breach of seawall led to flooding of plaintiff's property, and the local council / the defendant undertook repair of the wall but took an unreasonably long time for the defendant, which also caused the claimant / plaintiff to sue defendant for losses resulting from the flood. It was held that at the House of Lords, Lord Porter managed to mention that D was not liable for negligence and there was no assumption of responsibility other than a duty not to cause additional damage. Stated in quote, Lord Porter mentioned where damage was not caused by a positive act by an omission. There is no breach of duty. The only duty is to avoid causing damage, not to prevent future damage or shorten incidents of damage. So the loss suffered was due to the original breach, which continued due to defendant's omission to close it. The second local case that is mentioned that is relevant to our case is Jaswant Singh and Central Electricity Board and another, 1967. In this case, the first defendant argued that they should not be held liable for the losses suffered by the plaintiffs, as the losses are not reasonably foreseeable and that they are not in a position of legal proximity, or the neighborhood with the plaintiffs is that the losses that were suffered were something that is not within the reasonable contemplation of the first defendant. At the time when the first defendant was driving along the highway on 9th September 2005, it was held at Court Malaysia Original Civil Jurisdiction that the buffaloes on the highway were not straying on the highway and their behavior was only relevant in an action against the owner. The defendants were negligent in allowing a telephone wire to rest on electric wires for a long time, causing the damage that could lead to death or serious injury. In general, in conclusion, the first defendants were not breaching statutory duty, but both were liable in damages. and relevant to our cases, also proven that the first defendant was unaware and the second defendant was aware of the risk of the highway of the two tankers colliding.
There are several significance that we identify in our case. First is contributory negligence in environmental cases. The court's rejection of contributory negligence on the part of Puncak Niaga sets an important precedent. It clarified that primary responsibility rests with those whose negligence directly causes environmental harm, even if other parties could have taken additional precautions. Next, we will be looking into the next significance, which is foreseeability in negligence.
The decision reinforces the test of reasonably foreseeability in determining the liability of negligence. So the court ruled that it was foreseeable that the spillage of crude palm oil near a water catchment area would cause contamination. The damage downstream this serves has a precedent for similar cases involving industrial accidents with environmental consequences.
For the last significant is statutory duty and ignorance of the law. The judgment clarified that ignorance of the gazetted law is not a defence. By deeming public notice sufficient through gazetting, the court affirmed the principle that parties must be aware of legal obligations concerning protected environmental zones.
That's all from us. Thanks for watching our video.